Hello, and welcome to each one of you joining us for our online event entitled Religious Freedom, Where We Are and Where We Are Going. I'm Andrew Graham, a senior fellow here at the Religious Freedom Institute. And on behalf of all of us here at RFI, I want to thank you for honoring us with your time and attention today. If you are new to the Religious Freedom Institute, our mission is to promote religious freedom for everyone, everywhere. A mission that has grown increasingly urgent here in the United States and abroad in recent times. This is our inaugural event in our series entitled Courtrooms to Classrooms. So please be on the lookout for more to come. And now I'm delighted to introduce our two outstanding panelists today, two men of truly distinguished careers. First, let me introduce the Honorable Matthew J. Kaczmarek. Judge Kaczmarek is a judge on the United States District Court for the Northern District of Texas. I've had the pleasure of knowing Judge Kaczmarek for over 20 years now, and going back and forth to our time in law school together. And over that 20 years, I've had the pleasure of watching his remarkable career that has taken him all the way from a 1L at law school to a distinguished jurist now on the federal bench. Judge Kaczmarek is a native of Fort Worth, Texas. He attended Abilene Christian University, where he graduated summa cum laude. He then found his way to the University of Texas School of Law, where he again graduated with honors and was the executive editor of the prestigious Texas Review of Law and Politics. He then began his legal career at Baker Botts LLP as an associate in their Dallas office, Baker Botts being one of the truly premier law firms here in the United States. After a distinguished career in commercial and intellectual property litigation, he moved on to the U.S. Attorney's Office for the Northern District of Texas, where he served as an assistant United States attorney. During that time, he also served as an adjunct lecturer at the Southern Methodist University on free speech and received the Attorney General's Award for furthering U.S. national security. Judge Kaczmarek truly is a man for all seasons. At that time, he was also a founding member of the Fort Worth Lawyers Chapter of the Federalist Society, where I now have the privilege of serving as an officer myself. After a period of time in the nonprofit legal space, where he litigated religious freedom issues and served as counselor on all sorts of public policy issues regarding religious freedom, he is now serving on the United States District Court for the Northern District of Texas. President Trump nominated him in 2017, and he was confirmed by the United States Senate in 2019. He is a truly distinguished jurist, as I mentioned, and I will say he's done a remarkable job attracting some of the brightest legal minds to Amarillo, Texas, to clerk in his chambers. So if you're a young law student, you definitely want Judge Kaczmarek on your radar. And I would be remiss if I did not add to this distinguished career that he was just elected as a distinguished member of the Philadelphia Society. So congratulations, Judge, upon your election. Now let me introduce Professor James Soni of Stanford Law School. Professor Soni is the founding director of Stanford Law School's renowned Clinic on Religious Liberty, the first of its kind anywhere in the country. They do tremendous work there, training young lawyers of the utmost talent in how to litigate religious freedom cases. It's an organization you want to be sure to have on your radar screen if you're interested in the religious freedom space. Professor Soni received his BA with honors from Duke University and his JD from Harvard Law School. He then clerked on the Fifth Circuit Court of Appeals for Judge Edith Clement Brown and practiced with the law firm Horvitz and Levy in Los Angeles and then McGuire Woods in Richmond, Virginia. He's also served as a visiting professor at Harvard Law School, where he's helping Harvard start their own religious liberty clinic. Professor Soni has published numerous law reviews, and his work has been featured in the New York Times and the Wall Street Journal, as well as other leading media outlets. After their remarks, we will have a time for questions today. And now, Judge and Professor, thank you so much for joining us today. We're honored to have you here, and we look forward to your remarks. Thank you.
Thanks so much, Andrew. Thank you to the Religious Freedom Institute, Judge Kaczmarek. It's a joy to be with you all today. I'm going to start out by giving a lay of the land of religious freedom, where we are, where we're going, some overall thoughts. Then Judge Kazmarek will talk about some of the manifestations and deeper questions, illuminating some of the challenges we face, and then we'll discuss back and forth some recent and pending Supreme Court cases. And then, as Andrew said, we'll open it up for questions. So first, some background on my work that Andrew mentioned in the religious liberty field, and my perspective in particular in running a clinic in that field, because I think it offers some insights, some in the trenches insights into what we're going to be talking about today. As Andrew said, I teach in the field and serve as the faculty director of Stanford's Religious Liberty Clinic. And for those who aren't familiar, a law school clinic is where we teach and train students the real practice of law through real cases under our supervision, of course, but for real clients in actual lawsuits. And for us, we have the good fortune of doing this work exclusively in the religious liberty arena. It's a field of importance, of abiding importance since our country's founding, of course, but also one that has faced challenges in recent years, and those challenges that we'll discuss today. For all these challenges, though, I'm also happy to report that through the human-first, client-centered approach that we take at the clinic that meets people where they are in a spirit of liberty, mutual respect, and bridge building, our program has seen much success since its founding in 2012. We have enthusiastic support from students and faculty, and we've also helped inspire programs elsewhere. Andrew mentioned the program at Harvard that we've helped start. There's also a clinic now at Yale, Notre Dame, and University of Texas, the judge's alma mater, of course, and which I understand that Andrew helped play a role in getting that started. Now, I'm not describing this success to toot our own horn, but to only show that the world is hungry for these first principles that we'll be talking today and talking about today, and the harvest is plentiful. So although it may be, as Vice President Dick Cheney once said, that it's never darker than just before it's totally black, I have hope that if properly articulated and defended, religious liberty can continue in this country, and we can see, really a revisiting of these first principles in the lives of everyday people. At a widely covered Federalist Society talk last year, Justice Alito described his concern that, in his words, religious liberty is fast becoming a disfavored right. And any honest look at the examples he described, and which Judge Kazmarek will explore, shows this to be the case, in stark contrast with what was largely a bipartisan consensus as recently as the early 90s in the passage of the Religious Freedom Restoration Act. Since that act of unity, we've seen, for example, boycotts imposed over efforts at the state level to protect religious liberty in the wake of the Obergefell decision. We've seen an ongoing refusal to honor the well-established objections of the Little Sisters of the Poor to providing access to artificial contraception through their healthcare plans. We've seen harassment of small business owners who refuse to provide abortifacients or personalized services, even where such goods or services are readily available elsewhere. And in the COVID era, we've of course seen an approach in many states that discriminates against religious gatherings in the name of public health. At the risk of belaboring the point further, I'd also add to the list that Justice Alito shared the singling out of Muslims for disfavored treatment in land use, the refusal to accommodate minority faiths in the workplace, and the spike of anti-Semitism we're seeing in New York and elsewhere as further failures in honoring our first freedom. Now, there are many reasons for these threats to religious liberty, but allow me just to mention three. First, there is, of course, the fallout from the so-called culture wars over marriage, abortion, and other issues where one side or the other confuse the merits of the substantive policy question with whether it's permissible for the other side to even hold a contrary opinion. What often started as an effort for equality has morphed into a winner-take-all approach, and often with the aid of judges who substitute their judgment for the people. The resulting, if temporary, loss in the gamble has led many to the position that there's only one way of looking at these issues, even when there's a way to manage our disagreement without harm to one another. The Little Sisters, for example, aren't asking that the government outlaw contraception. They're just asking that they not be forced to provide it. The second underlying cause of current threats to religious liberty, beyond the culture wars, comes from what I describe as the French problem of embracing equality over liberty. Now, equality is a great rule of thumb 97% of the time. But when it comes to deeply human issues on which there's authentic and conscientious disagreement among people of goodwill, equality and liberty must be the rule. Treating religious beliefs the same as any other preference and regulating them accordingly misses the historic and human importance of not forcing people to the choice of violating their consciences in order to maintain their businesses, ministries, or standing as law-abiding citizens. We see this in the recent COVID cases. Third and lastly, in looking at all these issues, there's little question but the diminished role of religion and religious literacy in our increasingly secular culture, particularly among our elites, leads to disrespect or at least indifference to the importance of the issue. As Catholic University of America's President John Garvey put it, our society won't care about religious liberty if it doesn't care about God. So how to respond? Well, 3 suggestions, at least at a high level. And we'll get into more details with Judge Kaczmarek. To me, the key to getting past the culture wars is to stress and illustrate in the lives of real people the universality of religious liberty as a natural right. It's not some narrow political tool to advance a particular belief on a particular issue or part of a policy agenda, but that it belongs to all of us as a matter of our dignity as human persons, no matter how we choose to exercise it, including the choice not to be religious or to practice a faith. It belongs to all of us. As the Beckett Fund for Religious Liberty's founder, Seamus Hassan, once said, religious liberty isn't about who God is, it's about who we are. What many see in religious liberty as a problem can therefore, in fact, be a solution and to the benefit of everyone. At the clinic, therefore, we've made great strides in developing broad appreciation for religious liberty by, for example, representing the right of an interfaith homeless ministry to serve the poor at its church in the face of onerous zoning rules. A Muslim death row inmate seeking the solace of a chaplain by his side at the time of execution, or a Sikh truck driver seeking to maintain a beard without losing his job. Then, having defended religious liberty in these deeply human contexts, not only have we established helpful precedent, but our students and the public come to see the importance of such liberty in the more controversial cases, and more readily see the need to make space for one another, and particularly when the stakes are high. After all, you don't need constitutional protection if everyone agrees with the conclusion, right? This is about protecting minority faiths and minority views on these issues. My second proposal to resolving the seemingly intractable challenges we're exploring today, in addition to this idea of universality, is to show that norms of human equality are likewise best understood by seeing them as substantive rather than formalistic parameters that can, in fact, work in harmony with liberty. Those who follow Doug Laycock's work will recognize this as this idea of substantive neutrality, that it's not just equal on its face, but really understands the full human condition. And the exercise of liberty, of religious liberty, is part of what makes us truly human. Third and finally, and on a similar note, I suppose, we must revisit our understanding of rights and show that religious liberty for all is the rule to which burdens on religion are the exception. Of course, this is a notion that was urged by Locke, Madison, and others. Exceptions exist. After all, religious liberty is not unlimited, and there are important tensions to work through, but only where necessary to forestall actual harm to others. Rightly understood, then, religious liberty honors associated norms of pluralism, tolerance, and yes, equality. Fortunately, it seems the current Supreme Court majority largely grasps these norms, but the hold is tenuous and needs to expand beyond First Street. And so that's where I'm going to turn it now over to the judge to talk about some of the manifestations of these issues and some of the deeper causes. Judge?
Thank you, Professor. And because law flows downstream from politics and politics flows downstream from culture, I wanted to provide an overview for some of the reasons why the bipartisan consensus that gave rise to the Religious Freedom Restoration Act might be evaporating at this point in the 21st century. So turning to a March 29, 2021 Gallup poll, there is increasing evidence of decreasing religiosity. So in a Gallup poll published of that date, the researchers there found that the U.S. church membership rate fell below a majority for the first time in recorded history. In other words, membership affiliation in churches, mosques, synagogues, and elsewhere fell below 50% for the first time, at least as far back as records were kept. This parallels some of the findings of the 2014 Religious Landscape Study. And if you'll recall, the title of that study was The Rise of the Nuns. And here we're not referring to Professor Soni's clients or the Little Sisters of the Poor, but nuns as in N-O-N-E-S, those who report no religious affiliation, sometimes designated atheistic or agnostic. This is a catch-all category for people who don't identify with a particular religion or denomination. Some of these findings were confirmed 5 years later in another Pew Research Center report on the decline of Christianity, continuing at a rapid pace, or at least that was the title. And I'll quote from that research center. The telephone surveys conducted in 2018 and 2019 report that 65% of American adults describe themselves as Christian when asked about their religion. This is down 12 percentage points over the last decade. Meanwhile, the religiously unaffiliated, the nuns, their share of the population has grown to 26%. So if you look across this sociological data, it makes sense that people who don't personally partake in religious practice might be less and less inclined to defend it as a matter of principle. Also, the delta between older Americans and millennials and those younger than millennial continues to widen. Only half of millennials, according to the Pew Research Center, describe themselves as Christians, and 4 in 10 immediately identify as religious nuns. Again, that's N-O-N-E-S. This effect has landed most notably within the Democratic Party. So historically, the Democratic Party has been a sanctuary for religious dissidents, people who were outside the mainline white Anglo-Saxon Protestant tradition. My own relatives who were immigrants from Poland, sought sanctuary in the Democratic Party of urban centers. That's been at least that's been the pattern in American demographics. But at this point, about 6 out of 10 people who identify or lean towards the Democratic Party say they attend a religious service no more than a few times a year. And more than 4 in 10 self-identified white Democrats are religious nuns, N-O-N-E-S. And again, this is from the same Pew Research Data Center. And fully 7 in 10 white Democrats say that they attend religious service no more than a few times a year. So within 30 years, the Democratic Party, which had always been a sanctuary for religious minorities and those among persecuted religious groups, went from enacting and pushing the Religious Freedom Restoration Act in 1993 to 2019, at least sponsoring legislation that would expressly restrict the application of the Religious Freedom Restoration Act. So you see this in the 2019 Equality Act and No Harm Act, which are both sponsored by Democratic leaders. I think this cultural move towards religious disaffiliation is most pronounced in one of our major national parties, which had always been a sanctuary, a perceived and real sanctuary for persecuted religious minorities. So I think this in part explains why there's maybe less support for religious liberty as a general principle. I'd also refer the audience to a book by Christian Smith and Melinda Lundquist Denton. It's a famous book at this point. It's a 2005 book entitled Soul Searching. And what those authors find there is even within persons who identify as Christian, it doesn't necessarily reflect an orthodox strain, especially when it comes to some of the traditional tenets of Christianity. So I'll quote directly from that book. A significant part of Christianity in the United States is actually only tenuously Christian in any sense that is seriously connected to the actual historical Christian tradition, but has rather substantially morphed into what the authors call moralistic therapeutic deism. So MTD, as that phrase is abbreviated, consists of 5 tenets. Number 1, a God exists who created the world and watches over human life on earth. Number 2, God wants people to be good, nice, and fair to each other. Number 3, the central goal of life is to be happy and to feel good about oneself. Number 4, God need not to be involved in one's life except when needed to resolve a problem. This is sort of the Santa Claus view of the Creator. And then number 5, good people go to heaven when they die. So these are sort of the broad general tenets of what is an emerging actual civil religion of moralistic therapeutic deism. So where the polling data and some of the litigation reflects a divergence from what was the majority sort of baseline Christian default in American public life, I think that book and subsequent research reflects the shift away from a more orthodox strain of Christianity as a majoritarian religion to something resembling moralistic therapeutic deism instead. The next factor, at least demographically and sociologically, that has affected an evaporation of any religious consensus is the sexual revolution. And this really begins at the midpoint of the 20th century, continues through the latter half of the 20th century and into the 21st century. And in 2015, I published an article at the National Catholic Register that noted that the cultural upheaval of the sexual revolution had culminated in the effective deregulation of sex at the local, state, and national level. So as you track the legislation and the litigation, rules and regulations which were relevant to cohabitation, adultery, alienation of affection, divorce, contraception, abortion, and pornography, essentially evaporated as a matter of public policy, either through legislation or litigation. And so this is reflected in sort of the emergent mainstream view of such issues. In fact, the Pew Research Center data collected in 2019, and this is December 2019, so it's at the very end of the year, that data reflected an extant majority of mainline Protestants, an emergent majority of Roman Catholics, and an expected majority of young evangelicals support the deregulation of sex and personally engage in lifestyle choices that are consistent with that change. And with the exception of abortion, which remains controversial among self-identified Roman Catholics and evangelicals, you find even self-identified Christians assimilating to this new mainstream belief system. So I think that's a factor that is reflected in the continued litigation of so-called culture war issues. You have, even among self-identified Catholics, evangelicals, and Protestants, an assimilation to a post-sexual revolution worldview that affects the consensus that you may have seen at the turn of the 20th century. That consensus is now evaporated on those issues in the 21st century. And finally, I would like to point to a book I recently completed, The Rise and Triumph of the Modern Self. This is a 2020 volume by Carl Trueman, a professor who works in this space. And it is an interesting summary of the 400-year history of metaphysical, philosophical thought in the West, and it can be broken down into 4 parts. And I think he does explain some of the underlying metaphysics and philosophical changes that have taken place in the West generally, and in the United States in particular. And in part 1, Professor Trueman analyzes the work of sociologist Philip Rieff, philosopher Charles Taylor, and ethicist Alistair McIntyre to explain how modernity affected an inward focus on therapeutic fulfillment and authentic self-definition and self-actualization. So he contrasts this with earlier views of purpose and the meaning of life, which were always outward focused and focused on external objective facts and actions. As they document through sociology, philosophy, and ethics, there's been a definite shift towards therapeutic fulfillment, the inward self, and self-definition. Part 2 analyzes some of the philosophical work that underlies this shift, specifically the works of Rousseau, Nietzsche, Marx, and Darwin. It then dovetails those works with literature and the arts. So romantics like Percy Shelley and William Blake explain the 18th and 19th century shift in teleology. So moving from a medieval and a Renaissance model, which focuses on theistic, external, objective, and embodied definitions of personhood, you see with this philosophical and ethical shift a near atheistic focus on internal, subjective, and sensual materialism. And instead of a focus on personhood and the person's relationship to the creator, you see instead a focus on power and the politics of power. In part 3, Professor Truman explains how all of these philosophies and aesthetics of power were then sexualized in the works of Sigmund Freud, William Reich, and Marcuse. And they theorized that maximal sexual expression was necessary to free the human person from harmful restraint or oppression. So here you see an infusement of psychology and some new definitions of the human person, the human person sexualized, which certainly explains some of the culture war topics that are percolating through the culture and the courts right now. And then in part 4, Professor Truman explains how the 300-year trajectory of part 1, part 2, and part 3 converged and culminated in the sexual revolution in the latter half of the 20th century. And what emerges from there is a worldview that is opposed to any constraint on self-definition, self-actualization, and self-satisfaction, moral, ethical, theological, or otherwise. And so I think this book explains in DNA form the underlying sociological, philosophical, and ethical and metaphysical reasons for this shift, and why even people who self-identify with an Abrahamic religion, whether it's Christian, Jewish, LDS, or even Muslim, nonetheless are affected by this cultural shift. And I think that shows up in some of the culture war cases that Professor Soni references. So where are we now? When combined, these sociological, theological, and theoretical factors generate a culture that is focused on expressive individualism, self-definition, and therapeutic affirmation. It combines to create a politics that prioritizes expression over free exercise, prioritizes sex over religion, and safe spaces over debate and dialogue. And finally, in the law, you see a shift in emphasis away from hard rules of damages, case, and controversy towards an emphasis on dignitarian harms. You see this reflected in recent Supreme Court cases addressing targeting and animus, the idea that there is no bright line, but the court will intervene in a case in controversy where there is perceived mistreatment of a minority, religious or otherwise, where there is targeting, where there is provable animus. This certainly reflects the emphasis on psychology and the therapeutic mode. So I think that explains why we are there. And in conclusion, I'd make reference to an amicus brief that I participated in when I was in the nonprofit sector. It's a case that did not end up, the Supreme Court did not end up granting cert in the case, but it's an interesting case nonetheless. It's Knight versus Thompson. My colleagues and I joined Emory University professors there to argue that Native Americans historically suffered greater scrutiny in federal courts precisely because their religious beliefs and practices were unfamiliar and idiosyncratic to the court and the culture. This is most well illustrated by the infamous Ling case, where Native Americans struggled to explain to the court how the progress of the Industrial Revolution interfered with certain beliefs they had about sacred land and burial rights. As discussed in Knight v. Thompson vis-a-vis Native Americans, as traditional Abrahamic beliefs move more and more into a minority position and self-identified nuns increase, the percentage of Protestant, Catholic, and evangelical traditionalists decreases, and self-identified Christian practice of a faith begins to resemble moralistic therapeutic deism or something consonant with the sexual revolution. As a consequence, any plaintiff, any defendant in a case that runs afoul of this new extant civil religion will increasingly find themselves outside the mainstream and struggling to explain to the court in a case in controversy the nature of their beliefs. And as Native Americans have long struggled to explain to a majority of the court the nature of their beliefs and why lines must be drawn vis-a-vis free exercise, traditional Abrahamic beliefs, which are falling outside the mainstream, will be harder and harder to explain both to the court and to legislatures. So I think all of the above explains why we are where we are.
Thanks, Judge. Just a couple quick thoughts too. I don't know if folks have read the Ross Douthat's piece yesterday in the New York Times, reflecting on a lot of these dynamics in the recent Pew study. And it's, I think, as the judge points out, this really does culture, the downward effect of culture into law. And it's really important to understand these dynamics in order to tease out what's truly going on in these issues, and that ultimately, and I think as we've shown in our clinic work, yes, there's a lot of legal work to be done, but there's also a lot of cultural work to be done in terms of elevating the conversation. And though it's true that in many ways the law, to the degree to which most people will care about legal principle to the extent it affects them in everyday life, right? So this idea of religious liberty, what is it? Why does it matter? Why is it just this archaic concept from 200 years ago? Makes more sense, right, in terms of just the day-to-day experience of everyday people. But religious liberty, again, is for everyone. You don't have to be religious to appreciate its value. And even if you go back and look at Madison's Memorial and Remonstrance, you see, there are many reasons why, historical, human, and otherwise, why it's important for all people of goodwill to appreciate the importance of religious freedom, while appreciating that we have to figure out where the balance is going to be. So, Judge, why don't we then now turn to some recent cases and to see how this is played out at the Supreme Court. We have a list here, and of course we're open to questions as well on these cases. But why don't you start us off, Judge, if you would?
Yes, Professor. So I'll start with one of the most monumental cases on the docket, Bostock versus Clayton County. It was much watched by religious liberty practitioners because of its impact on the so-called culture war cases that are percolating through the system. This case involved companion cases which were consolidated to decide the question of Title VII sex discrimination and whether that protected class should be read to include sexual orientation and gender identity. In a nutshell, Justice Gorsuch framed the question before the court as straightforward and an application of textualism and but-for causation. So I'll quote from that opinion where Justice Gorsuch writes, "Today, we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer to that question is clear. When an employer fires an employee, quote, for being homosexual or transgender, that employee fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and indistinguishable role in that decision, exactly what Title VII forbids." So now famously, Justice Alito penned a blistering dissent. This was joined by Justice Thomas, and that dissent can basically be broken down into a preamble and three parts. The preamble is famous for the pirate ship metaphor. So I'll quote directly from Justice Alito's dissent, where he explains that the court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated, the theory that courts should update old statutes so that they better reflect the current values of society. And that's the basic tone and tenor of Justice Alito's dissent. And there's a lot of debate about textualism and which tools the late Justice Scalia might deploy in deciding the question. Part one of the dissent really focuses on that very definition of sex. And Justice Alito uses dictionaries, canons, hypotheticals, and syllogisms to argue that the phrase "because of sex" as it appears in the statute cannot be reasonably read to include sexual orientation, gender identity, or transgenderism, and that the phrase "discriminate against" cannot be logically reduced to a literalistic but-for causation test. Here, Justice Scalia repeatedly accuses Justice Gorsuch of, quote, breathtaking arrogance and rhetorical sleight of hand. And he highlights many instances where there are alleged logic leaps covered by words like inherently, inextricably, inescapably, and necessarily. So that's part one, which is really a fight about textualism as a statutory interpretation model, and both are sort of competing for the affection of the late great Justice Scalia. In part two, Justice Scalia takes that same thesis forward to the ordinary public meaning of those phrases, sex and discriminate against, and he explains that textualists do not read statutes as if they were messages picked up by a powerful radio telescope from a distant and utterly unknown civilization. So in part two, we get the radio telescope metaphor, and there Justice Scalia, and joined by Justice Thomas and others, explain that ordinary public meaning should control, not necessarily a hyper-technical literalistic reading of a phrase. And so there is this continuing debate within the opinion about which canons, which articles, which dictionaries, which evidence is relevant to ascertaining ordinary public meaning. Interestingly, if you look at footnote 22, Justice Alito cites an abstract of a Stanford Law article right next door to Professor Soni. James C. Phillips wrote an article, "The Overlooked Textual Evidence in the Title VII Cases, the Linguistic and Therefore Textualist Principle of Compositionality." This is an interesting take on ordinary public meaning and how it should work in a composition piece. So if you have time and you really want to know how textualism will play out in the future, I'd read footnote 2 in that law review article. Finally, Justice Alito in part 3 really takes the majority to task for its selective invocation of legislative history, and really opines that greater judicial humility is needed when we're digging into things like committee notes and contemporaneous opinions by appellate courts, and really cautions against the selective use of legislative history. And then, part 4 is what I would call the parade of horribles section of the opinion. Here, Justice Alito warns of, quote, far-reaching consequences which affect privacy, sports, housing, religious employers, healthcare, speech, and equal protection. He identifies those as the most likely candidates for future cases or controversy. And it turns out that Justice Alito's dissent was prescient, because shortly thereafter, on January 20, 2021, the Biden administration issued Executive Order 13988, which applies the Bostock definition and reading of the protected class sex to include Title IX, the Education Amendments, the Fair Housing Act, the Immigration and Nationality Act, and it further mandates that agency heads apply the Bostock opinion to their relevant caseload and agency actions. And then on March 26, 2021, the Department of Justice Civil Rights Division issued a memorandum on the application of Bostock to Title IX specifically. Curiously, this was signed by the same attorney who argued the plaintiff's case at the Supreme Court, now Principal Deputy Assistant Attorney General Pam Carlin. And so in a nutshell, that document, which was produced in a public domain article at The Hill magazine, it basically reasons that The Bostock definition and interpretation of the term sex as a protected class should apply with equal force to the Title IX education amendments and to all the places Title IX applies. So that will have some predictable effect on cases involving sports, housing, and privacy, at least as far as Title IX funds flow. So that's one of the recent cases decided that implicate some of these culture war cases. It'll certainly implicate any protected, I should say, any statute or any regulation where the protected class sex appears. And so I think on the horizon you can anticipate cases and controversies, DOJ memoranda, dear colleague letters from the Department of Education trying to apply Bostock on a going forward basis. I think you'll likely see cases and controversies revolving around the religious employer exemption, which appears as an exemption in the statutory text of Title VII. The majority in Bostock does not finally decide that question, so it's likely that you'll see religious employers and ministries struggling to apply Bostock to that exception, and eventually that'll reach the court. So in the categories identified by Justice Alito, you'll see continued litigation and application of the opinion in Bostock. I'd also just quickly note the media reaction to the case, which reflects some of the cultural divides that we discussed earlier. The New York Times and Washington Post heralded Bostock as a fairly straightforward application of non-discrimination principle. It didn't attract too many fireworks. In stark contrast, if you look at the so-called conservative media, whether it's National Review or the Washington Times or First Things Magazine, and some of those papers, you see an absolute blowback. You see articles in the pages of National Review and First Things reconsidering the efficacy of textualism, sometimes more broadly referred to as originalism. The opinion precipitated an absolute crisis among those obsessed with canons and modes of constitutional interpretation. So that fight continues. That so-called fight on the right has continued since Bostock and likely will in the cases that follow.
Thanks, Judge. I just wanted to talk briefly about another case, or at least one more case that touches on some of these cultural issues. But I want to emphasize, and this is the Little Sisters of the Poor case, I want to emphasize that although a lot of the public media attention has cast the Little Sisters of the Poor case as this potentially divisive culture war battle, one of the overlooked dynamics in the litigation has been the broad agreement and bipartisan agreement across the board for in the Supreme Court. I think folks don't often pay attention to that, and it's an important theme. So if you look at the first imposition of fines against the Little Sisters, I think it was Justice Sotomayor issued a New Year's Eve injunction to protect the Little Sisters. Then there was the Zubik decision, or at least the remand following Justice Scalia's death. That was an 8-0 decision, basically telling the government and the Little Sisters to work it out. And then you had last June's 7-2 decision in favor of the protection of the Little Sisters and through a regulation. And why is this important? Well, it's important, I think, because it shows, yes, it outlines the legal obligation and some of and obviously it applies RFRA to protect the Little Sisters. But it's also important, I think, because it shows agreement on the human dimension of what's going on here. And to quote some of Justice Alito's opinion in the most recent case, he emphasizes this human dimension. And in his Federal Society speech, he said, quote, "The Little Sisters are women who have dedicated their lives to caring for the elderly poor, regardless of religion. They run homes that have won high praise. Here are some testimonials filed in our court by residents of their homes. Carl Berquist: the Little Sisters do everything to make us happy. I feel I'm part of the family, and that's a great feeling. They'll keep you alive 10 years longer than any place else because they love you. Carol Hassel: in a nutshell, I'd say this about the Little Sisters. A little bit of heaven fell from the sky one day and landed into my apartment. And this is really, in many ways, what we are about at our clinic. Yes, there are tough cases. Yes, there are culture wars going on about us. But is there a way that we can find common ground? Is there a way that we can figure out these issues without it being a zero-sum game? And I would suggest that one of those ways, yes, again, decisions have to be made sometimes. Sometimes they're 5-4. But if we focus on the human, if we focus on what's really going on here and trying to avoid these winner-take-all battles, I think there's a majority, if not more, at the Supreme Court ready to take that up. So I think that's a heartening tale. We'll see where it goes from here, but for now, I think there's been a lot of progress and bridge building there. Judge, you want to talk a little bit about Espinoza and?
Sure, and so this is a good example of what Professor Soni is talking about. An emerging consensus, especially in Establishment Clause cases, consonant with the emerging actual civil religion of whether you term it moralistic therapeutic deism or you use some of the other literature to define what is sort of a new majoritarian view on God and religion. Cases that involve perceived unfairness or a violation of equality principles stand to gain at least 5 votes or more at the Supreme Court. So Espinoza is one of those cases, and it really dovetails with the litigation against Blaine Amendments in this country. As many in your audience will know, the Blaine Amendments were designed to essentially defund Catholic parochial schools. These amendments were implemented during a sweep of anti-Catholic bigotry. And I think the audience, especially younger members, need to remember these Blaine Amendments were enacted during a time when public school was a synonym for Protestant school. And so on a state-by-state basis, a lot of states enacted versions of the Blaine Amendment. And then there have been multiple rounds of litigation to challenge the constitutionality of these statutes, which effectively place parochial schools and religious schools at a severe disadvantage when it comes to funding. And this case involved a 2015 Montana statute that created a scholarship program for private scholarship organizations. These organizations use the money to find scholarships for children to attend private schools. In this case, the plaintiffs sought to use those funds at Stillwater Christian School in Kalispell, Montana. And in 2018, the Montana Supreme Court struck down that tax credit program as violative of the state constitution's ban on aid to churches and religions. So this is a version of the Blaine Amendment applicable to school funding. And here, the Supreme Court sided with the plaintiffs, and John Roberts wrote the opinion. The opinion was 5-4, but very strongly written to apply the strictest possible scrutiny to cases where the state or federal government have set up divergent regimes for funding. And what's interesting is Chief Justice Roberts runs through a series of arguments raised by the Montana Department of Revenue that likely would have prevailed some 50 years ago, definitely around the time of the enactment of the Blaine Amendments. But one by one, each of these Establishment Clause arguments fall. And interestingly, you see in Espinoza a shift from the Establishment Clause as a sword against private and parochial entities to a shield. The Establishment Clause is not meant to affect a sort of French-style scrubbing of all religiosity from the public square and public fisc, but instead to allow participation on equal footing. And again, this is more consonant with emerging mainstream attitudes on religion. If you're going to have a private scholarship organization and you're going to target or specifically exclude religious schools, a majority of the court will view that with the strictest possible scrutiny. Interestingly enough, and this is more on the theoretical level, Justice Thomas and Neil Gorsuch signed an opinion reiterating Justice Thomas's long-held view that the Establishment Clause is far more limited than the court's reiteration of federalism principles. And then Justice Alito files a concurrence there where he highlights the history of the Blaine Amendments and the pernicious anti-Catholic bigotry that motivated that. If the audience is interested in Blaine Amendments, the history, there's a really good summary article in the pages of First Things magazine. It's written by Philip Hamburger. It was written in response to the Trinity Lutheran case, but it gives a real good snapshot of how the progressive movement and adherents of scientism combined in the 19th and 20th century to try to drive religion to the margins of society as a form of scientific progress. And so that's a really good article. It's a good summary of how this country could get to a point where state legislature after state legislature were enacting Blaine amendments to effectively purge Catholic schools and Catholic ministries from the public fisc. So in a way, Justice Roberts' majority opinion there reverses in a polar reversal way the tilt of the field when it comes to the Establishment Clause and public funding of faith-based organizations.
Thanks, Judge. I see we're coming up on. I guess we have about 20 minutes left. Maybe we should just close with maybe just a brief description of. I think you're going to talk a little bit about the Tandon case from last Friday night, and I'll maybe just talk a little bit about the what to watch for cases, and well, there's Fulton, and then also maybe you can close us out with the Thomas More Law Center case.
Okay, so let me just very quickly highlight the hardest pronounced case in the Supreme Court lineup, and that's Uzu Ega Bunam versus Przewski. So I don't struggle with the Polish surnames, but the other name is spelled Uzegbunam. It's my understanding it's pronounced Uzu Eg Bunam. This case, very quickly in a nutshell, involves the use of nominal damages in constitutional litigation as a basis for standing, and whether a plaintiff can satisfy the Lujan Spokio third element of redressability simply because they retain nominal damages or a claim for nominal damages. The court says yes, and sides with the plaintiff in this case. This will be monumental to Professor Soni's clinic. Government agencies often try to moot constitutional litigation by changing a policy, thereby denying any actual damages. But this case involved nominal damages. There's a very lengthy description of the English American law tradition. It's written by Justice Thomas, the resident textualist and architect of original public meaning. And he basically explains how nominal damages have worked historically and why they're appropriate here as a basis for standing. Just very quickly on the Tandon case, what I like to call the midnight surprise from the Supreme Court. This is a 5-4 ruling granting a stay pending appeal in a case that involved some of the coronavirus and COVID restrictions. It was somewhat of a surprise because of the way this case law had been percolating up to this point. In that unsigned opinion, the majority wrote that the Ninth Circuit's failure to put California's COVID restrictions on hold was erroneous. But you see that Justice Roberts indicates in his writing that he would have denied the request. So an unfamiliar breakdown in a familiar line of cases involving COVID restrictions and alleged differential treatment of churches. You can go download that. If you weren't up at midnight when the opinion came, it's now available in the public domain, but that's a case I know Professor Sony's watching.
Thanks, Judge. And then lastly, the two cases that are pending that religious liberty folks are watching. One is Fulton. That's the dispute over the city of Philadelphia's decision to halt the Catholic Church's participation in foster care services in the city. This case, among the questions presented, is whether or not the Supreme Court should revisit the Smith decision from 1990, which essentially held that if there is a law or regulation that is neutral and generally applicable, that it doesn't that strict scrutiny is not necessary under the First Amendment, and obviously that was what RFRA was responding to in the early 90s. So it'll be interesting to see. I think most court watchers predict that the court will likely go down the road of discrimination or targeting or that sort of thing, as opposed to reversing Smith or overruling Smith. We'll see. And it also could well turn on the contracting, the ability of cities to contract and make choices and allocating contracts. So a lot of issues there to unpack. It's a little hard to read the tea leaves but even thinking about the Tannen case, the court hasn't really given a lot of clues as to whether or not it's going to revisit Smith. So we'll see. And then lastly, the Thomas More Law Center case. Judge, you want to mention that?
Yeah, so Thomas Law More Society versus Becerra. So that case is pending, and it calls into question a famous case, NAACP versus Alabama Patterson. And it asks whether that standard can be satisfied absent any showing that a blanket governmental demand for the individual identities and addresses of major donors can be narrowly tailored. So this case is watched intensely in the nonprofit sector because it's going to revisit some of the freedom of speech and association issues tied to donor anonymity and the disclosure of donor lists. So as you might imagine, in my 5 years in the nonprofit sector, donor anonymity is of concern to faith-based organizations, 501c3s, any church that follows a Form 990 in an era of cancel culture, antics, and boycotting donor anonymity, which has long been protected, at least since the Civil Rights era. That's up and pending now in the Thomas More Law Center case, and it's Thomas More Law Center versus Becerra, and you should probably sign up for a case tracker on that one because it would affect any of the audience who operate in the nonprofit sector and involve donor work.
Thanks, Judge. Andrew, do you want to lead us in some questions?
Yeah, I think that'd be perfect. So Professor and Judge, thanks for those terrific comments. Y'all covered an astounding amount of ground in just under an hour: cultural issues, legal issues. And I thought it was especially fantastic the way you tied all of those issues together. I've got a few questions coming in, but I'll begin with a question of my own. So Professor, you mentioned earlier on what you called the French problem of people now thinking of equality as perhaps a more important constitutional value than liberty. Obviously, in 1993, we had the Religious Freedom Restoration Act, emphasis on freedom. And now we have, in 2019, 2020, the Equality Act, emphasis on equality. And it seems to me that one of the issues that we are facing as a society, and that really has a lot to say about where religious freedom is going, is the shift from the rank ordering of liberty or freedom, if you will, as the brightest star in our constitutional firmament, to the idea of equality as more important, perhaps, at least in certain people's minds. Do you see any possibility, at least in the near future, for the pendulum to swing back the other direction, that is, back toward liberty and less toward equality? Or do you see the current trends continuing for some time to come?
Well, thanks, Andrew. I think that there is hope, there's promise that I think we can have both. And that's, I think, what I was trying to emphasize, that if you only have equality to the exclusion of understanding how human beings operate and what's of deep importance to them, you're going to miss that dimension of human life, and it's going to cause a lot of problems. And so, yes, equality, but equality in a substantive way that appreciates, just as you would say it's not a great analogy, but in a disability context, you'd say, look, there's human beings should have access to the workplace, and in the ADA, right, it says 40 million people are underemployed or don't have access to the workplace. Isn't there some give we can have to recognize their humanity? And so too in the religious liberty field. And I think telling those human stories, showing that these aren't our clients. Most of these cases aren't about the culture wars. Most religious liberty cases are about just regular folks trying to live, serve, and survive and follow the law, and in a manner that's consistent with their religious conscience. Nothing more, nothing less. And I think telling those stories, illustrating in the lives of real people that importance, we can make a lot of progress. And we've done that in the clinic. I would point to this death penalty chaplaincy dispute that's gone back and forth to the Supreme Court. At first, there was a case involving an inmate in Alabama for years had provided a chaplain to executions. The official chaplain was Protestant Christian, and then a Muslim inmate asked for a chaplain of his own faith, understandably, and was denied. And the challenge was brought up to the court on Establishment Clause grounds, and the court saw fit, rightly, to say, well, you can't have it that way. It's an Establishment Clause problem to deny. It's an equality problem, right, to deny the inmate this solace in his final minutes. And I think there was broad agreement of that. That's just unfair. It's unequal. Then the next question comes, well, the response of Alabama was, okay, then maybe we won't have any chaplains in there at all. And the problem with that, of course, is yes, it's equal. It's treating everyone equal, but it really is an approach that doesn't fully recognize what's at stake. And so we've been part of an effort to continue to fight for a change that recognizes the liberty interest, if you will, if you want to put it in those terms, but that equality, it goes very far, but there's a missing step there. So I'm not suggesting that we don't emphasize equality, but I am suggesting that it has to work in tandem and together, just as the Establishment Clause and free exercise are, two wings of the same bird, or however you want to look at it. So I'm optimistic, but I think it has to start with a cultural appreciation of authentic pluralism, of common humanity, and really appreciating that religious liberty is both about religious liberty and equality.
Yeah, that's fantastic. Judge, do you have anything you'd like to add there, or?
I do think the professor is correct that we're seeing a shift away from, speaking of the French approach to religion. I never know how to pronounce this because I don't speak French. Laïcité, I think, is the phrase. The French Revolution and subsequent republics, they had a very different solution to the matter of religious pluralism, and that was to sandblast the public square of any indicia of religion, thereby rendering it neutral for all. I do think you saw that vision manifest in some of the 20th century Supreme Court cases, which emphasized neutrality as the guiding light. There's this idea that the government must essentially sanitize the public square so that nobody is offended by a menorah or a creche. I think that sort of strict separationist reading of the Establishment Clause is less and less persuasive to this court. And I do think an emergent culture that does prioritize equality and fair treatment is not going to use the Establishment Clause as a sword to excise all indicia of religiosity, but is instead going to fashion solutions more consonant with the crowded public square. There was I think it's Professor Foster wrote a book called The Contested Public Square. I think laïcité in that sort of sanitized square solution to religious pluralism is definitely receding as a popular reading of the Establishment Clause and what it is designed to do. So in cases involving that clause and in an increasingly diverse and religiously pluralistic society, I don't think there's much evidence of that strict separationist view taking hold, at least with the current members of the court.
Yeah, that's great. I would just add myself. I did think it was interesting that Justice Gorsuch in the Espinoza case, as I read the concurrences, does seem to sign on to the view that Justice Thomas holds, that incorporation of the Establishment Clause was something that should have never happened in the first place. I did think that was interesting and one of those little known or much overlooked facts, whereas it's been an academic theory to this point. Now there's at least a second justice who seems inclined to say that incorporation against the states may have been the wrong idea. All right, so turning back to free exercise issues. So we've mentioned the possible fate of Smith arising from the City of Philadelphia versus Fulton case. Without asking you all to read the tea leaves, do you have any ideas as to what the fate of Smith might be in light of your following of that particular case?
I guess I would say that there probably we'll see, of course, but I think there may be just as many lessons to be drawn from the COVID cases in terms of what does it mean to be generally applicable. For example, when you have exceptions for certain types of gatherings, and you saw this dispute in Tandon. If you pull that the decision and the dissent, you see, are these apples to apples? Is it apples to oranges or watermelons? I guess Justice Kagan said. So, I think there's a lot of work being done I wouldn't say undermine Smith. It's in many views, in many ways, just elaborating on, okay, what does it mean to be generally applicable? What are we really talking about here? And the court has definitely now moved toward what I think Doug Laycock calls the most favored nation status for religious liberty. And I think that signals, at least to me, that the court will likely continue to work with Smith, though maybe cabinet. And that's my expectation from the oral argument. I don't expect a full reversal, but I think that there's the court seeing how unwieldy a sort of cold, rigid approach is in the lower courts. And you saw the court say, we told you 5 times what our view is on this, and I think some of that frustration is probably with Smith and some of the challenges, but that doesn't mean that it'll fall in Fulton. And as I mentioned, there are a lot of other issues going on in that case as well.
Yeah. So obviously, without commenting on any pending cases or controversies, just looking at this as a purely academic question, I think the professor is right that the current trajectory reflects sort of a piecemeal approach to limiting the scope of Smith on a case-by-case basis. It reminds me of neutrality analysis in the 1990s when Justice O'Connor and then Justice Kennedy represented the fifth and deciding vote in every Establishment Clause case. There was as advocates are wont to do, there was a rush to wrap every argument in the garment of neutrality, understanding that the de facto reasonable observer was Sandra Day O'Connor. So I think you're seeing a similar jurisprudential trajectory vis-a-vis Smith. Where necessary, the court will distinguish Smith based on the particulars of a case, but I don't yet see 5 votes to overturn it outright. And as the professor noted, there is briefing on that, in particular briefing by the Beckett attorneys in the Fulton case. So, I do think, having worked in that sector, I do think you'll probably see at least a line of amici asking the court to overturn Smith where applicable in every case moving forward. But it appears to be that work will be done in part and on a case-by-case basis. I don't yet see, who would have the pen on the 5th and deciding vote to just outright overturn it. I don't yet know how that would happen.
All right. Well, we've got just under 4 minutes to go. So at this point, I think I'd like to close the questions off and just offer to each one of you to give us any closing reflections that you might have and to round out our time together. So Judge, Professor, I'd love to hear any closing thoughts, and then we'll wrap it up.
Well, I'll allow the professor to go first since he's actually in the trenches as an advocate right now.
Sure. Well, thank you, Judge. It's been great to be with you again, and thank you, Andrew, and to Religious Freedom Institute for putting on this program. I think it's really important to have these conversations. To go through the case law and read tea leaves, and it's intellectually interesting. But I do want to just leave, I think, with the story of where I started, which is in the small experiment laboratory of our clinical work. I think we see, as I said before, that although these cultural questions are really important and they do manifest in even the cases that we do in our clinic, that really remembering the human, remembering what is this all about? What is religious liberty and religious freedom all about? And it's different than those substantive questions, right? Those disputes, and my concern is that those disputes, though important in their own right, will overwhelm, and we will forget what religious liberty is truly about, which is again human beings trying to live, work, survive, and follow the law as best they can and be good citizens in a way that's true to themselves as human beings, and most importantly, in exercise of their faith. And so to honor that and to really try and work together for principled pluralism, for an understanding of the human, I think not only is the right answer, but it's also a universal answer that should protect everyone and really should be, again, a solution rather than a problem. And so through our work in the clinic and bringing people together and trying to find those solutions, I am optimistic that work can be done, but it has to be done consistently and with mutual respect and with charity and good cheer. So thanks again for this opportunity, Judge.
Yeah, so just very briefly, for the audience and practitioners who are interested in this space, I would recommend following administrative law. So whether it is Philip Hamburger's book on administrative law or some of the writings of other experts, follow what happens in the fourth headless branch as a canary in the mine, if you will, for what comes next. So in addition to everything we discussed about the Article 1, Article 2, and Article 3 branches, consider the fourth headless branch and look for executive orders, DOJ memoranda, dear colleague letters from the Department of Education, FAQs from the Department of Labor, OFCCP, all of this APA rulemaking protocol and process, I think will play an outsized role in 21st century religious liberty litigation. If you're trying to preview which cases or controversies might actually percolate up to the court, I think you can see those cases unfolding in the administrative state. And I think when there is turnover in an administration, you can see the sort of switch in policy reflected in agencies and how they interpret different provisions and how they apply, the Religious Freedom Restoration Act. So this is not much taught in law school, and so I think practitioners and those watching the space should look at the administrative state. I think I was working in the Department of Justice when there was a change in administration, there was a change at the Attorney General level, and you could see the shift in public policy priorities, which eventually led to litigation in DOJ memoranda that came from DOJ Maine. And so if you want to track where this is all going, I would keep a binder of all agency statements, all memoranda. Look at the Department of Justice, look at HHS, look at the Department of Labor. You'll see a shift in priorities. Every administration is authorized and entitled to implement the policies that got them elected. And so I think, if you're trying to predict where this all goes, don't neglect the fourth headless branch.
Well, Judge, Professor, thank you so much for taking the time to be with us today. It's been a true pleasure to speak with you both. Your insights were fantastic. And to each one of you joining us, we thank you for your time and attention, and we look forward to seeing you again soon at future programs. Thanks again, everyone. Bye-bye.
Thank you.